Paragraph. The reference to altering an existing law includes references to repealing it and reenacting it with modifications or making different provisions in lieu thereof, and to modifying it, and in the preceding paragraph, written law includes any instrument having the force of law, and in this and the preceding paragraph references to the repeal and reenactment of an existing law shall be construed accordingly. 3. In relation to any person who is a member of a disciplined force raised under a law in force in Guyana, nothing contained in or done under the authority of the disciplinary law of that force shall be held to be inconsistent with or in contravention of any of the provisions of this title, other than Articles 138, 140, and 141. 4. In relation to any person who is a member of a disciplined force, raised otherwise than as aforesaid and lawfully present in Guyana, nothing contained in or done under the authority of the disciplinary law of that force shall be held to be inconsistent with or in contravention of any of the provisions of this title. Enforcement of Protective Provisions, 6 of 2001, 153. 1. Subject to the provisions of paragraph 6, if any person, including a person acting on behalf of another who is not acting in his or her own name, or a person acting on behalf of a group or an association acting on behalf of its members, alleges that any of the provisions of Articles 138 to 151 inclusive has been, is being, or is likely to be contravened in relation to him or her, or, in the case of a person who is detained, if any other person alleges such a contravention in relation to the detained person, then, without prejudice to any other action with respect to the same matter which is lawfully available, that person or association or that other person may apply to the High Court for redress. 2. The High Court shall have original a. To hear and determine any application made by any person in pursuance of the preceding paragraph, b. To determine any question arising in the case of any person which is referred to it in pursuance of the next following paragraph, and may make such orders, issue such writs, and give such directions as it may consider appropriate for the purpose of enforcing or securing the enforcement of any of the provisions of Article 138 to 151 inclusive. 3. If in any proceedings in any court subordinate to the High Court, any question arises as to the contravention of any of the provisions of Articles 138 to 151 inclusive, the person presiding in that court shall refer the question to the High Court, unless, in his or her opinion, the raising of the question is merely frivolous or vexatious. 4. Where any question is referred to the High Court in pursuance of paragraph 3, the High Court shall give its decision upon the question, and the court in which the question arose shall dispose of the case in accordance with that decision, or if that decision is the subject of an appeal under this Constitution to the Court of Appeal, in accordance with the decision of the Court of Appeal. 5. Parliament may confer upon the High Court such powers in addition to those conferred by this article as may appear to Parliament to be necessary or desirable, for the purpose of enabling the High Court more effectively to exercise the jurisdiction conferred upon it by this article. 6. Parliament may make provision with respect to the practice and procedure a. Of the High Court in relation to the jurisdiction and powers conferred upon it by or under this article, b. Of the High Court and the Court of Appeal in relation to appeals to the Court of Appeal from decisions of the High Court in the exercise of such jurisdiction. C. Of subordinate courts in relation to references to the High Court under paragraph 3, including provision with respect to the time within which any application, reference or appeal shall or may be made or brought, and, subject to any provision so made, provision may be made with respect to the matters aforesaid by rules of court. Interpretation 154. In this title, unless the context otherwise requires, contravention in relation to any requirement includes a failure to comply with that requirement, and cognate expressions shall be construed accordingly. Court means any court of law having jurisdiction in Guyana other than a court established by a disciplinary law, and in Articles 138 and 140, a court established by a disciplinary law. Disciplinary law means a law regulating the discipline of any disciplined force. Disciplinary force means a. Any group of persons functioning whether wholly or partially as a naval, military, paramilitary, or air force. b. A police force. c. A prison service. d. A fire service. Legal representative in relation to any court or other tribunal means a person entitled to practice as an attorney at law before such court or tribunal. Member, in relation to a disciplined force, includes any person who, under the law regulating the discipline of that force, is subject to that discipline, and national service means service in any disciplined force, a principal purpose of which is the training of people with a view to advancing the economic development of Guyana. Title I. A Protection of Human Rights, Human Rights of the Individual, 10 of 2003, 4th Schedule, 154. A1. Subject to paragraphs 3 and 6, every person, as contemplated by the respective international treaties set out in the 4th Schedule to which Guyana has acceded, is entitled to the human rights enshrined in the said international treaties, and such rights shall be respected and upheld by the executive, legislature, judiciary, and all organs and agencies of government, and, where applicable to them, by all natural and legal persons, and shall be enforceable in the manner hereinafter prescribed. 2. The rights referred to in paragraph 1 do not include any fundamental right under this Constitution. 3. The state shall, having regard to the socio-cultural level of development of the society, take reasonable legislative and other measures within its available resources to achieve the progressive realization of the rights provided for in paragraph 1. 4. If any person alleges that any of the rights referred to in paragraph 1 has been, is being, or is about to be contravened in relation to him or her, then, without prejudice to any other action with respect to the same matter which is lawfully available, that person may apply to the Human Rights Commission, in such manner as the Commission may prescribe, for redress. 5. Nothing contained in this article shall be construed so as to abrogate any human right not enumerated herein, which a person had at the time of the commencement of this article. 6. The state may divest itself or otherwise limit the extent of its obligation under any of the treaties listed in the fourth schedule, provided that 2/3 of the elected members of the National Assembly have voted in favor of such divestment or limitation. Fourth schedule, Title II Parliament, Disqualifications for 155. 1. No person shall be qualified for election as a member of the National Assembly who, election as members, August 14, 2000, a. is, by virtue of his or her own act, under any acknowledgement of allegiance, obedience or adherence to a foreign power or state, b. is a person certified to be insane or otherwise adjudged to be of unsound mind under any law in force in Guyana, c. is under sentence of death imposed on him or her by a court, or is serving a sentence of imprisonment, by whatever name called exceeding 6 months imposed on him or her by a court, or substituted by competent authority for some other sentence imposed on him or her by a court, or is under such a sentence of imprisonment the execution of which has been suspended, or d. holds or is acting in the office of any judge of the Supreme Court of Judicature, a member of the Public Service Appellate Tribunal, the Elections Commission, the Judicial Service Commission, the Public Service Commission, the Teaching Service Commission or the Police Service Commission, the Director of Public Prosecutions, the Ombudsman or the Auditor General. Paragraphs 2, 3, 4 and 5 repealed by Act No. 14 of 2000. 6. Without prejudice to the provisions of paragraph 1, Parliament may provide that a person shall not be qualified for election as a member of the National Assembly in any of the following cases, that is to say, a. if he or she holds or is acting in any office that is specified by Parliament, and the functions of which involve responsibility for, or in connection with the conduct, of an election or the compilation or revision of any register of electors, for the purposes of an election. b. Subject to any exceptions and limitations prescribed by Parliament, if he or she has any such interest in any such government contract as may be so prescribed. c. Subject as aforesaid if I. he or she holds or is acting in or performing the functions of any office or appointment prescribed by Parliament either individually, or by reference to a class of office or appointment. He or she belongs to any armed force of Guyana, or to any class of persons that is comprised in any such force, or he or she belongs to any police force of Guyana, or to any class of persons that is comprised in any such force. d. If during such period not exceeding 5 years preceding the election day as may be prescribed by Parliament, he or she, I, has been convicted by a court of an offense relating to excitement of hostility or ill will against any person or class of persons on the grounds of his or her or their race, or t. has been convicted by a court of any offense connected with an election that is so prescribed, or has been reported guilty of such an offense, by the High Court in proceedings under Article 163, provided that Parliament may empower the court to exempt a person from disqualification for election on account of such a conviction or report, if the court deems it just so to do. 7. For the purposes of paragraph 1c, a. 2 or more sentences of imprisonment that are required to be served consecutively shall be regarded as separate sentences if none of those sentences exceeds 6 months, but if any one of those sentences exceeds that term, they shall be regarded as one sentence, and b. No account shall be taken of a sentence of imprisonment imposed as an alternative to or in default of the payment of a fine. 8. In paragraph 6b, government contract means any contract made with the government of Guyana or with a department of that government, or with an officer of that government contracting as such. 156. 1. A member of the National Assembly shall vacate his or her seat therein. Tenure of seats of members of Assembly. The National, August 14, 2000, August 22, 2007. If he or she resigns it by writing A under his or her hand addressed to the Speaker, or, if the office of the Speaker is vacant or the Speaker is absent from Guyana, to the Deputy Speaker. Provided that, if the President certifies that the member had resigned for the purpose of giving further service to the public, the member, if otherwise qualified, shall be eligible to be re-elected to the Assembly in accordance with any provision made under Article 63. b. If he or she is absent from the sittings of the Assembly for such period, and in such circumstances as may be prescribed in the rules of procedure of the Assembly. c. If he or she ceases to be a citizen of Guyana. d. Subject to the next following paragraph, if any circumstances arise that, if he or she were not a member of the Assembly, would cause him or her to be disqualified for election as a member thereof, by virtue of the preceding article, or of any law enacted in pursuance thereof. E. In the circumstances and to the extent set out in Article 178(4) f. In the case of a member who has been elected pursuant to the provisions of Article 61, or Article 162, whenever Parliament is dissolved. G. Subparagraphs G and H repealed by Act No. 14 of 2000. 2. A. If circumstances such as are referred to in subparagraph D of the preceding paragraph arise in relation to a member of the Assembly by virtue of the fact that he is adjudged to be of unsound mind, sentenced to death or imprisonment, or convicted or reported guilty of an offense, and if it is open to the member to appeal against the decision either with the leave of a court or other authority, or without such leave, he or she shall forthwith cease to perform his or her functions as a member of the Assembly, but, subject to the next following subparagraph, he or she shall not vacate his or her seat until the expiration of a period of 30 days thereafter, provided that the Speaker may, at the request of the member, from time to time extend that period for further periods of 30 days to enable the member to pursue appeal against the decision, so, however, that extensions of time in the aggregate 150 days shall not be given, without the approval of the Assembly signified by resolution. B. If, on the determination of any appeal, such circumstances continue to exist, and no further appeal is open to the member of the Assembly, or if by reason of the expiration of any period for entering an appeal or notice thereof, or the refusal of leave, or for any other reason, it ceases to be open to the member to appeal, he or she shall forthwith vacate his or her seat. C. If at any time before the member of the Assembly vacates his or her seat such circumstances as aforesaid cease to exist, his or her seat shall not become vacant by reason of those circumstances, and he or she may resume the performance of his or her functions as a member of the Assembly. 3. A member of the National Assembly elected on a list shall cease to be a member of the Assembly if a. He or she declares in writing to the Speaker or to the representative of the list from which his or her name was extracted that he or she will not support the list from which his or her name was extracted. B. He or she declares in writing to the Speaker or to the representative of the list from which his or her name is extracted his or her support for another list. The representative of the list from which his or her name was extracted indicates in writing to the Speaker that after meaningful consultation with the party or parties that make up the list that the party or parties have lost confidence in that member, and the representative of the list issues a written notice of recall to that member, and forwards a copy of that notice to the Speaker. 4. The Speaker shall declare the seat of a member of the National Assembly vacant where a. The Speaker receives a written declaration of the member of the National Assembly as provided for in paragraph 3a, or bb. The representative of the list issues a notice of recall as provided for in paragraph 3c. Speaker and Deputy Speaker. August 14, 2000, 157. A person shall vacate the office of Speaker or Deputy Speaker whenever the Assembly first meets after a dissolution of Parliament, and also a. In the case of a Speaker elected from among the members of the Assembly, or in the case of the Deputy Speaker, I. If he or she ceases to be a member of the Assembly for any cause other than a dissolution of Parliament, provided that where a person, who holds the office of Speaker, ceases to be a member of the National Assembly by virtue of the holding of an election referred to in Article 156, 1f, he shall not by reason thereof vacate the office of Speaker if at such election he or she is re-elected as a member of the Assembly. He, if by virtue of paragraph 2a of the preceding article he or she is required to cease to perform his or her functions as a member, Assembly, or t. If he or she is appointed to be a minister or a parliamentary secretary. B. In the case of a Speaker elected from among persons who are not members of the Assembly, if he or she ceases to be a citizen of Guyana, or if any circumstances arise that would cause him or her to be disqualified for election as a member of the Assembly by virtue of Article 155, or of any law enacted in pursuance thereof. If he or she announces the resignation of his or her office to the Assembly, or if by writing under his or her hand addressed, in the case of the Speaker, to the Clerk of the Assembly, or in the case of the Deputy Speaker, to the Speaker, or if the office of Speaker is vacant or the Speaker is absent from Guyana, to the Clerk, he or she resigns that office, or d. In the case of the Deputy Speaker, if he or she is elected to be Speaker, Clerk and Deputy Clerk, 158, 1. Subject to the provisions of the next following paragraph, the Clerk of the National Assembly shall vacate his or her office when he or she attains the age of 65 years or such later age as may, in any particular be prescribed by the Commission appointed under paragraph 4. 2. The Clerk shall be removed from office by the President if but shall not be so removed unless the National Assembly, by a resolution which has received the affirmative votes of a majority of all the elected members thereof, has resolved that he or she ought to be so removed for inability to discharge the functions of his or her office, whether arising from infirmity of body or mind or any other cause, or for misbehavior. 3. The provisions of paragraphs 1 and 2 shall apply to the Deputy Clerk as they apply to the Clerk. 4. Subject to the provisions of Article 222. The terms of service, including salary and allowances of the clerk and deputy clerk, shall be determined from time to time by a commission consisting of the Speaker, as chairman, the minister responsible for finance, or a person nominated by that minister to represent him or her at any meeting of the commission, and one other minister designated from time to time by the Prime Minister. 5. A person who is a public officer may, without ceasing to hold office in the public service, be appointed in accordance with the provisions of this article to the office of clerk or deputy clerk, but a. No such appointment shall be made without the concurrence of the appropriate service authority. b. The provisions of paragraphs 1, 2, and 3 shall in relation to an officer so appointed apply, subject to the provisions of subparagraph d as respects his or her service as clerk or deputy clerk, but not as respects his or her service as a public officer. An officer so appointed shall not, during his or her continuance in the office of clerk or deputy clerk, perform the functions of any public office, and d. An officer so appointed may at any time be appointed by the appropriate service authority to assume or resume the functions of a public office, and he or she shall thereupon vacate his or her office as clerk or deputy clerk, but no appointment under this subparagraph shall be made without the concurrence of the Speaker. 6. In the preceding paragraph, the appropriate service authority means the authority in which, under the provisions of this Constitution, is vested the power to make appointments to the public office held by the person to be appointed as clerk or deputy clerk, or the functions of which the clerk or deputy is to be appointed to assume or resume, as the case may be. 7. The functions conferred by this article on the Speaker shall, if there is no person holding the office of Speaker, or if the Speaker is absent from Guyana, or is otherwise unable to perform those functions, be performed by the Deputy Speaker. Qualifications and disqualifications for electors. 3 of 2001, 159. 1. No person shall vote at an election unless he or she is registered as an elector. 2. Subject to the provisions of paragraphs 3 and 4, a person shall be qualified to be registered as an elector for elections if and shall not be so qualified unless, on the qualifying date, he or she is of the age of 18 years or upwards, and either a. is a citizen of Guyana or b. is a Commonwealth citizen who is not a citizen of Guyana, and who is domiciled and resident in Guyana and has been so resident for a period of 1 year immediately preceding the qualifying date, and c. satisfies such other qualifications as may be prescribed by or under any law. 3. No person shall be qualified to be so registered who on the qualifying date is a person certified to be insane or otherwise adjudged to be of unsound mind under any law in force in Guyana. 4. No person shall be qualified to be so registered if during such period, not exceeding 5 years preceding the qualifying date as may be prescribed by Parliament, he or she has been convicted by a court of any offense connected with elections that is so prescribed, or has been reported guilty of such an offense by the High Court in proceedings under Article 163, provided that Parliament may empower the court to exempt a person from disqualification for registration on account of such a conviction or report, if the court deems it just so to do. 5. In this article, the qualifying date means such date as may be appointed by or under an Act of Parliament as the date with reference to which a register of electors shall be compiled or revised. Electoral System. August 14, 2000, 160. 1. Subject to the provisions of the next following paragraph, the system of proportional representation referred to in Article 62, for the election of such number of members of the National Assembly as shall be determined by the Assembly, shall be as follows. A. Votes shall be cast throughout Guyana in favor of lists of candidates. B. Each elector shall have 1 vote and may cast it in favor of any of the lists, and c. The seats of the said elected members in the Assembly as determined under this paragraph shall be allocated between the lists in such a manner that the proportion that the number of such seats allocated to each list bears to the number of votes cast in favor of that list is as nearly as may be the same for each list, thus minimizing the level of disproportionality between the percentages of votes earned by lists and the percentages of seats allocated to lists in the cases of individual geographical constituencies, if they exist, and of the Assembly taken as a whole. 2. Parliament may make provision for the division of Guyana into such number of geographical constituencies, not being more than half the number of the elected members of the Assembly as Parliament may prescribe, and for the election in each such constituency of such number of members of the Assembly as Parliament shall, subject to paragraph 4, prescribe, but, if Parliament makes provisions as aforesaid, then a. A person may stand as a candidate for election in any such geographical constituency only if, in such manner as Parliament may prescribe, he or she has declared that he or she supports, or has otherwise identified himself or herself with one and only one of the lists related to that geographical constituency, not with a list in any other geographical constituency, and not with any lists of another party, and b. those of the said seats in the Assembly as determined under paragraph 1, for which members are not elected in geographical constituencies, as aforesaid shall be allocated between the contesting parties, in accordance with the results of the voting throughout Guyana in favor of the lists of the contesting parties in such a manner that the proportion that the number of seats allocated to each party, when added to the number of members identified with that party's lists elected in the geographical constituencies, bears to the number of votes cast in favor of that party, is as nearly as may be the same for each party, thus minimizing the level of disproportionality between the percentages of votes earned by parties and the percentages of seats allocated to parties in the Assembly. 3. Subject to the provisions of this Constitution, Parliament may make provision, I. For the registration of electors, t. For the manner in which lists of candidates shall be prepared, including the provision in a list of the names of a sufficient number of candidates to enable any vacancies to be filled under subparagraph 7, and which manner shall allow voters to be sure which individuals they are electing to the National Assembly. E. For the manner in which the number of seats to be allocated to each list shall be calculated in order to give effect to the provisions of paragraph 1 or paragraph 2, as the case may be. IV. For the combination of lists of candidates for the purpose of the allocation of seats, but not for the purpose of voting. V. For the extraction from the lists and declaration of names of the candidates who have been elected, and for such provision for extraction to take into account the proportion that women form of the electorate. Vi. For the manner in which elections of members of the National Assembly shall be held pursuant to the provisions of paragraphs 1 and 2. 7. For the filling of vacancies among the seats of members of the National Assembly where such vacancies are caused otherwise than by a dissolution of Parliament. 7. Generally for the conduct of elections of members of the National Assembly and for giving effect to the provisions of this Constitution relating thereto. B. I. For the criteria for the participation of political parties in the general election. C. For the formulae to be used to translate votes for a contesting party into seats for that party in the National Assembly. For the minimum number or proportion of female candidates on a party's list and in all parties' lists taken together. IV. For the minimum number or proportion of female candidates on a party's lists for geographical constituencies taken individually or together. V. For the maximum percentage or the number of geographical constituencies a party can contest in which its lists contain no female candidate. 4. The total number of seats in the National Assembly that are derived from geographical constituencies shall be such that the number of seats not derived from geographical constituencies is sufficiently large to correct any overall disproportionalities that might arise from the allocations of seats to geographical constituencies. Political parties prohibited from causing ethnic division. August 14, 2000, 160A1. All persons, institutions, and political parties are prohibited from taking any action or advancing, disseminating, or communicating any idea which may result in racial or ethnic division among the people. 2. For the purposes of paragraph 1, Parliament shall by law make provision for offenses and penalties, including penalties preventing or disbarring any person or political party from contesting any election for membership, or being a member, as the case may be, of the local democratic organs or of the National Assembly. Elections Commission. 2 of 2000. 161. 1. There shall be an Elections Commission for Guyana consisting of a chairman, who shall be a full-time chairman and shall not engage in any other form of employment, and such other members as may be appointed in accordance with the provisions of this article. 2. Subject to the provisions of paragraph 4, the chairman of the Elections Commission shall be a person who holds or who has held office as a judge of a court, having unlimited jurisdiction in civil and criminal matters in some part of the Commonwealth, or a court, having jurisdiction in appeals from any such court, or who is qualified to be appointed as any such judge, or any other fit and proper person, to be appointed by the President from a list of 6 persons, not unacceptable to the President, submitted by the Leader of the Opposition, after meaningful consultation with the non-governmental political parties represented in the National Assembly, provided that, if the Leader of the Opposition fails to submit a list as provided for, the President shall appoint a person who holds or has held office as a judge of a court, having unlimited jurisdiction in civil and criminal matters in some part of the Commonwealth, or a court having jurisdiction in appeals from any such court, or who is qualified to be appointed as any such judge. 3. In addition to the chairman, there shall be 6 members of the commission who shall be appointed in the following manner. A. 3 members to be appointed by the President, acting in his or her own deliberate judgment, and B. 3 members to be appointed by the President, acting in accordance with the advice of the Leader of the Opposition tendered after meaningful consultation with non-governmental political parties represented in the National Assembly. 4. A person shall be disqualified for appointment as the chairman or other member of the commission if he or she is an alien. 5. The chairman or any other member of the Elections Commission shall vacate his or her office if any circumstances arise that, if he or she were not a member of the commission, would cause him to be disqualified for appointment as such. 6. The provisions of Article 225, which relate to removal from office, shall apply to the office of the chairman or other members of the Elections Commission, and for the purposes of paragraphs 4 and 6 of that article, the prescribed authority shall be the Prime Minister, provided that in the case of the members referred to in paragraph 3b, the Prime Minister shall meaningfully consult the Leader of the Opposition before tendering any advice to the President under Article 225(4). 7. If, by reason of his or her illness, absence from Guyana, or suspension under Article 225, the Chairman or any other member of the Elections Commission is unable to perform his or her functions as such, a temporary chairman or other member, as the case may be appointed in his or her place. 8. The provisions of this article shall apply in relation to the appointment of a temporary chairman or other member of the Elections Commission, and to a temporary chairman or other member appointed in accordance with this article, as they apply in relation to the chairman or other member, as the case may be, of the Elections Commission in whose place he or she is appointed, provided that his or her appointment shall have effect only for the period ending when the person in whose place he or she has been appointed resumes his or her functions as, or ceases to be, the chairman or other. Appointment of Staff of Elections Commission, Secretariat of the Commission. 2 of 2000. Member, as the case may be, of the Commission. 161a. 1. The Elections Commission shall be responsible for the efficient functioning of the Secretariat of the Commission, which shall comprise the officers and employees of the Commission, and for the appointment of all the staff to the offices thereof, inclusive of all temporary staff, recruited for the purposes of boundary demarcation, registration of persons and elections, and shall have the power to remove and to exercise disciplinary control over such staff. 2. The Elections Commission may, by directions in writing and subject to such conditions as it thinks fit, delegate any of its powers under paragraph 1 to any one or more members of the Commission, or by such directions and subject to such conditions as it thinks fit, delegate such powers to such officers of the Commission as the Commission may determine. 3. Before the Elections Commission, or any member thereof, or other person exercising powers under this article appoints to or to act in any office referred to in paragraph 1, any person who holds or is acting in any office, power to make appointments to which is vested under this Constitution in the Judicial, the Teaching, the Police or the Public Service Commission, the Elections Commission or that member or other person, shall first seek and obtain the approval of the Commission in which that power is vested. 4. Where a public officer is appointed to an office referred to in paragraph 1, he or she shall, subject to the said paragraph 1, remain a public officer, unless the Commission determines that that office shall be independent of any other commission. 5. Nothing in this article shall be construed as precluding the Elections Commission from appointing any person who is not a public officer to an office referred to in paragraph 1. Role of political parties in the conduct of elections through the Elections Commission, August 14, 2000. Functions of the Elections Commission, August 14, 2000, 161 billions. It is hereby declared that the role of political parties and their nominees in the conduct of elections by the Elections Commission shall be limited to their participation in determining policy, monitoring the electoral process and the conduct of the election, but does not include active management of the electoral process. 162. 1. The Elections Commission shall have such functions connected with or relating to the registration of electors, or the conduct of elections, as are conferred upon it by or under this Constitution, or, subject thereto, any Act of Parliament, and, subject to the provisions or this Constitution, the Commission, a. shall exercise general direction and supervision over the registration of electors and the administrative conduct of all elections of members of the National Assembly, and b. shall issue such instructions and take such action as appear to it necessary or expedient to ensure impartiality, fairness and compliance with the provisions of this Constitution or of any Act of Parliament on the part of persons exercising powers or performing duties connected with or relating to the matters aforesaid. 2. Notwithstanding anything to the contrary in this Constitution, if the Elections Commission is satisfied that the holding of an election pursuant to the provisions of paragraph 2 of Article 60, or Article 162, on the day appointed therefore would be attended either generally, or in a particular area, by danger or serious hardship, it may, after consultation with the Prime Minister and the Leader of the Opposition, by notice published in the Gazette, determination of questions as to membership and elections. August 14, 2000. Postpone the holding of the election to a day specified in the notice, or b. postpone the voting in any area specified in the notice to a day so specified. 163. 1. Subject to the provisions of this article, the High Court shall have exclusive jurisdiction to determine any question, a. regarding the qualification of any person to be elected as a member of the National Assembly, b. whether either generally or in any particular place an election has been lawfully conducted or the result thereof has been, or may have been, affected by any unlawful act or omission, t. the seats in the Assembly have been lawfully allocated, a seat in the Assembly has become vacant, or iv. any member of the Assembly is required under the provisions of Article 156, 2, and 3 to cease to exercise any of his or her functions as a member thereof, c. regarding the filling of a vacant seat in the Assembly, or d. whether any person has been validly elected as Speaker of the Assembly from among persons who are not members thereof, or having been so elected, has vacated the office of Speaker. 2. Proceedings for the determination of any question referred to in the preceding paragraph may be instituted by any person including the Attorney General, and where such proceedings are instituted by a person other than the Attorney General, the Attorney General, if he or she is not a party thereto, may intervene, and, if he or she intervenes, may appear or be represented therein. 3. An appeal shall lie to the Court of Appeal. A. From the decision of a judge of the High Court granting or refusing leave to institute proceedings for the determination of any question referred to in paragraph 1. B. From the determination by the High Court of any such question, or against any order of the High Court made in consequence of such determination. 4. Parliament may make provision with respect a. The circumstances and manner in which, and the conditions upon which proceedings for the determination of any question under this article may be instituted in the High Court, and an appeal may be brought to the Court of Appeal in respect thereof. B. The consequences of the determination of any question under this article, and the powers of the High Court in relation to the determination of any such question, including, without prejudice to the generality of the foregoing power provision, empowering the High Court to order the holding of a fresh election throughout Guyana or a fresh ballot in any part thereof, or the re-allocation of seats in whole or in part, and c. The practice and procedure of the High Court in relation to the jurisdiction and powers conferred upon it by or under this article, and of that court, and the Court of Appeal in relation to appeals to the Court of Appeal under this article. And subject to any provision so made, provision may be made with respect to the matters aforesaid by rules of court. 5. In this article, reference to any person being elected shall be read and construed as a reference to any person being elected under paragraph 2 of Article 60 or under Article 162, as the case may be. Procedure for altering this Constitution. 164. 1. Subject to the provisions of paragraphs 2 and 3, a bill for an act of Parliament to alter this Constitution shall not be passed by the National Assembly unless it is supported at the final voting in the Assembly by the votes of a majority of all the elected members of the Assembly. 2. A bill to alter any of the following provisions of this Constitution, that is to say, a. This article, Articles 1, 2, 8, 9, 18, 51, 66, 89, 99 and 111, and b. Articles 3, 4, 5, 6 and 7, 10 to 17, inclusive, 19 to 49, inclusive, 52 to 57, inclusive, 59, 60, 62, 63, 64, 65, 67, 68, 69, 70, 72. Insofar as it relates to the number of regions, 90 to 96, inclusive, 98, 108, 110, 116, 120 to 163, inclusive, but excepting Article 132, 168 to 215, inclusive, but excepting Articles 173, 185, 186, 192, and 3, and 193, 222, 223, 225, 226, 231, and 232, excepting the definition of financial year, shall not be submitted to the President for his or her assent unless the bill, not less than 2 and not more than 6 months after its passage through the National Assembly, has, in such manner as Parliament may prescribe, been submitted to the vote of the electors qualified to vote in an election and has been approved by a majority of the electors who vote on the bill, provided that if the bill does not alter any of the provisions mentioned in subparagraph A, and is supported at the final voting in the Assembly by the votes of not less than 2/3 of all the elected members of the Assembly, it shall not be necessary to submit the bill to the vote of the electors. 3. In this article, a. References to this Constitution or to any particular provision thereof include references to any other law insofar as that law alters the Constitution, or as the case may be that provision, and b. References to altering this Constitution, or any particular provision thereof, include references to repealing it, with or without reenactment thereof, or the making of different provision in lieu thereof, to modifying it and to suspending its operation for any period. Regulation of Procedure. 165. 1. Subject to the provisions of this Constitution, the National Assembly may regulate its own procedure, and may make rules for that purpose. 2. The Assembly may act notwithstanding any vacancy in its membership, including any vacancy not filled when the Assembly first meets after the commencement of this Constitution or after any dissolution of Parliament, and the presence or participation of any person not entitled to be present at, or to participate in the proceedings of the Assembly, shall not invalidate those proceedings. Presiding in the Assembly, Oaths of Members. 166. 1. The Speaker, or, in his or her absence, the Deputy Speaker, or, if they are both absent, a member of the National Assembly, not being a minister or a parliamentary secretary, elected by the Assembly for the sitting, shall preside at any sitting of the Assembly. 2. References in this article to circumstances in which the Speaker or Deputy Speaker is absent include references to circumstances in which the office of Speaker or Deputy Speaker is vacant. 167. No member of the National Assembly shall take part in the proceedings of the Assembly, other than proceedings necessary for the purpose of this article, until he or she has made and subscribed before the Assembly the oath of office, provided that the election of a Speaker and Deputy Speaker of the Assembly may take place before the members thereof have made and subscribed such oath. 168. 1. Save, as otherwise provided by this Constitution, all questions proposed for decision in the National Assembly shall be determined by a majority of the votes of the members present and voting. 2. Except as provided by the next following paragraph, the Speaker or other member presiding in the Assembly shall not vote unless on any question the votes are equally divided, in which case he or she shall have and exercise a casting vote. 3. A Speaker elected from among persons who are not members of the Assembly shall have neither an original nor a casting vote, and if, upon any question before the Assembly when such a Speaker is presiding, the votes of the members are equally divided, the motion, quorum, shall be lost. 169. If objection is taken by any member of the National Assembly present, that there are present in the Assembly besides the person presiding less than 1/3 of all the elected members of the Assembly, and after such interval as may be prescribed in the rules of procedure of the Assembly, the person presiding ascertains that there are still present less than 1/3 of all the elected members, he or she shall thereupon adjourn the Assembly. Mode of legislation. August 17, 2000, 170. 1. Subject to the provisions of Article 164, the power of Parliament to make laws shall be exercised by bills passed by the National Assembly and assented to by the President. 2. When a bill is presented to the President for assent, he or she shall signify that he or she assents, or that he or she withholds assent. 3. Where the President withholds his or her assent to a bill, he or she shall return it to the Speaker within 21 days of the date when it was presented to him or her for assent with a message stating the reasons why he or she has withheld his or her assent. 4. Where a bill is so returned to the Speaker, it shall not again be presented to the President for assent unless within 6 months of the bill being so returned upon a motion supported by the votes of not less than 2/3 of all the elected members of the National Assembly the Assembly resolves that the bill be again presented for assent. 5. Where the National Assembly so resolves that a bill be again presented for assent, the bill shall be so presented and the President shall assent to it within 90 days of its presentation. 6. A bill shall not become law unless it has been duly passed and assented to in accordance with this Constitution. Introduction of bills, etc. 171. 1. Subject to the provisions of this Constitution and of the rules of procedure of the National Assembly, any member of the Assembly may introduce any bill or propose any motion for debate in, or may present any petition to, the Assembly, and the same shall be debated and disposed of, according to the rules of procedure of the Assembly. 2. Except on the recommendation or with the consent of the Cabinet signified by a minister, the Assembly shall not a. Proceed upon any bill, including any amendment to a bill which, in the opinion of the person presiding, makes provision for any of the following purposes. I. For imposing or increasing any tax, i.e., for imposing any charge upon the Consolidated Fund, or any other public fund of Guyana, or for altering any such charge otherwise than by reducing it. E. For the payment, issue or withdrawal from the Consolidated Fund or any other public fund of Guyana of any monies not charged thereon or any increase in the amount of such a payment, issue or withdrawal, or IV. For compounding or remitting any debt due to Guyana, or proceed upon any motion including any amendment to a motion, the effect of which, in the opinion of the person presiding, would be to make provision for any of the purposes aforesaid, privileges, etc. of members of the National Assembly. 172. 1. Subject to the provisions of paragraphs 2, 3, and 4, Parliament may by law determine the privileges, immunities, and powers of members of the National Assembly, and the members thereof. 2. No civil or criminal proceedings may be instituted against any member of the Assembly for words spoken before, or written in a report to, the Assembly or to a committee thereof, or by reason of any matter or thing brought by him or her therein by petition, bill, resolution, motion, or otherwise. 3. For the duration of any session, members of the Assembly shall enjoy freedom from arrest for any civil debt. 4. No process issued by any court in the exercise of its civil jurisdiction shall be served or executed within the precincts of the Assembly while the Assembly is sitting, or through the Speaker, the Clerk, or any officer of the Assembly. 173 to 176, Title III, Articles 173 to 176, repealed by Act No. 14 of 2000, Election of President, 2 of 2000. Title IV, the President, 177. 1. Any list of candidates for an election held pursuant to the provisions of Article 62 shall designate not more than one of those candidates as a presidential candidate. An elector voting at such an election in favor of a list shall be deemed to be also voting in favor of the presidential candidate named in the list. 2. Where a. there is only one presidential candidate at the election, or b. there are two or more presidential candidates, if more votes are cast in favor of the list in which a person is designated as presidential candidate than in favor of any other list, that presidential candidate shall be deemed to be elected as president, and shall be so declared by the chairman of the Elections Commission, acting only in accordance with the advice of the chief election officer, after such advice has been tendered to the Elections Commission at a duly summoned meeting. 3. Where no person is elected as president under paragraph 2, and where the votes cast in favor of each list are equal in number, or where the votes cast in favor of each of two or more lists are equal in number but greater than the number of votes cast in favor of any other list, the chairman of the Elections Commission, acting in the presence of the Chancellor and of the public, shall by lot choose one of the lists in respect of which the votes are equal in either of the circumstances aforesaid, laws of Guyana, and shall declare the presidential candidate designated in that list to be duly elected as president. 4. The Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president insofar as that question depends upon the qualification of any person for election or the interpretation of this Constitution, and any decision of that court under this paragraph shall be final. 5. Subject to the provisions of this Constitution, Parliament may make provision for giving effect to the provisions of this title and, without prejudice to the generality thereof, may make provision a. for the conduct of elections to the office of President, and b. with respect to the persons, by whom, the manner in which and the conditions upon which proceedings for the determination of any question such as is mentioned in the preceding paragraph may be instituted in the Court of Appeal. And, subject to any provisions made under subparagraph b, provision may be made with respect to the matters referred to therein by rules of court. 6. Subject to the provisions of paragraph 4, an instrument which a. is executed under the hand of the chairman of the Elections Commission, and b. states that a person named in the instrument was declared elected as president at an election held pursuant to the provisions of Article 62, shall be conclusive evidence that the person so named was so elected, and no question as to the validity of the election as the president of the person so named shall be inquired into any court. Tenure of office of president. August 14, 2000, 178, 1. The office of president shall become vacant if the person holding it a. dies, or b. resigns it by writing under his or her hand addressed to the speaker, or c. ceases to hold it by virtue of the provisions of Article 92, 179 or 180. 2. A person assuming the office of president in accordance with the provisions of this Constitution shall be disqualified for any other office, employment, or appointment to which this paragraph applies, and accordingly on entering upon the duties of the office of president, shall vacate any such other office, employment, or appointment held by him or her. 3. The preceding paragraph applies to the offices of Speaker, Member, Clerk or Deputy Clerk of the National Assembly, and Judge of the Supreme Court of Judicature, Member of the Elections Commission, the Judicial Service Commission, the Public Service Commission, the Teaching Service Commission, or the Police Service Commission, any public office, employment in any armed force of Guyana, and any paid appointment as a member or employee of a body corporate established by law for public purposes, laws of Guyana. 4. During any period when a minister is performing the functions of the office of president under Article 96 or 179, or has assumed the office under the proviso to Article 95(1), his or her seat in the National Assembly shall be regarded as vacant, and may be temporarily filled in accordance with any provision made under Article 163. At the expiration of the period, the person temporarily filling the seat shall vacate it, and the seat shall thereupon be resumed by the minister, provided that the person so vacating the seat shall be eligible for re-election under any provision made as aforesaid. Removal of president on grounds of incapacity. 179. 1. If the members of the National Assembly whose names appeared as candidates on the same list as that of the president at the last election held pursuant to Article 62 resolve, upon a motion supported by the votes of majority of all of them, that the question of the physical or mental capacity of the president to discharge the functions of his or her office ought to be investigated, and the Prime Minister so informs the Chancellor shall appoint a board consisting of not less than 3 persons selected by him or her from among persons who are qualified as medical practitioners under the law of Guyana, and the board shall inquire into the matter and shall make a report to the Chancellor stating the opinion of the board whether or not the president is, by reason of any infirmity of body or mind, incapable of discharging the functions of his or her office. 2. If the board reports that the president is incapable of discharging the functions of the office of president, the Chancellor shall certify in writing accordingly, and thereupon the president shall cease to hold office. Laws of Guyana. 3. Where the Prime Minister informs the Chancellor that a resolution has been passed pursuant to paragraph 1, that the question of the physical or mental capacity of the President to discharge the functions of his or her office should be investigated, the President shall, until another person assumes the office of President, or the board appointed in pursuance of paragraph 1 reports that the President is not incapable of discharging the functions of his or her office, whichever is the earlier, cease to perform the functions of his or her office, and those functions shall be performed by a. the Prime Minister, or b. during any period when there is no Prime Minister or the Prime Minister is absent from Guyana or is unable, by reason of physical or mental infirmity, to discharge the functions of his or her office by such member of the Cabinet, being an elected member of the National Assembly, as shall be elected by the members referred to in paragraph 1, provided that any person performing the functions of the office of President under this paragraph shall not dissolve Parliament, or, save on the advice of the Cabinet, revoke any appointment made by the President. 4. A motion for the purposes of paragraph 1 may be proposed by any of the members referred to therein at any meeting of such members convened by the Prime Minister. Removal of President for violation of Constitution or gross misconduct. August 17, 2000. 180. 1. If notice in writing is given to the Speaker of the National Assembly, signed by not less than 1/2 of all the elected members of the Assembly, of a motion alleging that the President has committed any violation of the Constitution or any gross misconduct, and specifying the particulars of all the allegations, and proposing that a tribunal be established under this article to investigate those allegations, the Speaker shall, a. If Parliament is then sitting or has been summoned to meet within 5 days, cause the motion to be considered by the Assembly within 7 days of the notice, or b. If Parliament is not then sitting and notwithstanding that it may be prorogued, summon the Assembly to meet within 21 days of the notice, and cause the motion to be considered at that meeting. 2. Where a motion under this article is proposed for consideration by the National Assembly, the Assembly shall not debate the motion, but the person presiding in the Assembly shall forthwith cause a vote to be taken on the motion, and, if the motion is supported by the votes of not less than 2/3 of all the elected members of the Assembly, shall declare the motion to be passed. 3. If the motion is declared to be passed under paragraph 2, a. The Chancellor shall appoint a tribunal which shall consist of a chairman, and not less than 2 other members selected by the Chancellor from among persons who hold or have held office as a judge of a court having unlimited jurisdiction in civil and criminal matters, in some part of the Commonwealth, or a court having jurisdiction on appeals from any such court. b. The tribunal shall investigate the matter, and shall report to the National Assembly whether it finds the particulars of the allegations specified in the motion to have been sustained. c. The President shall have the right to appear and be represented before the tribunal during its investigation of the allegations against him or her. 4. If the tribunal reports to the National Assembly that the tribunal finds that the particulars of any allegation against the President specified in the motion have not been substantiated, no further proceedings shall be taken under this article in respect of that allegation. 5. If the tribunal reports to the National Assembly that the tribunal finds that the particulars of any allegations specified in the motion have been substantiated, the Assembly may, on a motion supported by the votes of not less than 2/3 of all elected members of the Assembly, resolve that the President has been guilty of such violation of the Constitution, or, as the case may be, such gross misconduct as is incompatible with his or her continuance in office as President. And, if the Assembly so resolves, the President shall cease to hold office upon the 3rd day following the passage of the resolution. Salary and allowances of President. 181. 1. The President shall receive such salary and allowances as may be prescribed under the provisions of Article 222. 2. A person who has held the office of President shall receive such pension, or upon the expiration of his or her term of office, such gratuity as may be prescribed by Parliament. Any such pension or gratuity shall be a charge on the Consolidated Fund. Immunities of President. 182. 1. Subject to the provisions of Article 180, the holder of the office of President shall not be personally answerable to any court for the performance of the functions of his or her office, or for any act done in the performance of those functions, and no proceedings, whether criminal or civil, shall be instituted against him or her in his or her personal capacity, in respect thereof, either during his or her term of office or thereafter. 2. Whilst any person holds or performs the functions of the office of President, no criminal proceedings shall be instituted or continued against him or her in respect of anything done or omitted to be done by him or her in his or her private capacity, and no civil proceedings shall be instituted or continued in respect of which relief is claimed against him or her, or anything done or omitted to be done in his or her private capacity. 3. Where provision is made by law limiting the time within which proceedings of any description may be brought against any person, the period during which any person holds or performs the functions of the office of President shall not be taken into account in calculating any period of time prescribed by that law for bringing any such proceedings as are mentioned in paragraph 2 against him or her. Title 5 The Executive, Subtitle 1 Ministers etc. Tenure of Office of Ministers. August 14, 2000, 183. 1. The office of a minister who was not an elected member of the Assembly at the time of his or her appointment, and has not subsequently become such a member, shall become vacant if the holder of the office a. ceases to be a citizen of Guyana, or b. if he or she becomes disqualified for election as a member of the Assembly by virtue of Article 155, or of any law enacted in pursuance thereof. 2. The office of any other minister shall become vacant if the holder of the office a. ceases to be a member of the Assembly for any cause other than a dissolution of Parliament. B. Is not a member of the Assembly when the Assembly first meets after a dissolution of Parliament, or C. Is by virtue of Article 156(2) or 3 required to cease to perform his or her functions as a member of the Assembly. 3. The office of any minister shall become Leader of the Opposition, 2 of 2000 August 14, 2000, vacant, A. If he or she resigns it by writing under his or her hand addressed to the President, B. If the President so directs, or C. On the election of any person to the office of President pursuant to the provisions of Article 177, 184, 1, the Leader of the Opposition shall be elected by and from among the non-governmental members of the National Assembly at a meeting held under the chairmanship of the Speaker of the National Assembly, who shall not have the right to vote. 2. The office of the Leader of the Opposition shall become vacant if A. The holder thereof ceases to be a member of the Assembly for any cause other than a dissolution of Parliament. B. He or she is not a member of the Assembly when the Assembly first meets after the dissolution of Parliament. C. By virtue of Article 156(2) or 3, he or she is required to cease to exercise his or her functions as a member of the Assembly, or D. His or her removal from office is effected under the provisions of the next following paragraph. Constitution of the Cooperative Republic of Guyana Cap. 101-153. 3. Where 1/3 of the non-governmental members of the Assembly represent to the Speaker that the Leader of the Opposition no longer enjoys their confidence, the Speaker shall call a meeting of all the non-governmental members at which it shall be decided whether the Leader of the Opposition shall be removed from office. The removal shall be effected by the votes of a majority of all the non-governmental members. 4. The election and removal from office of the Leader of the Opposition shall be by a show of hands. Attorney General, 185. 1. A person shall not be qualified to be appointed as Attorney General unless he or she holds such qualifications as may be prescribed by Parliament and is a citizen of Guyana. 2. If the Attorney General is an elected member of the National Assembly at the time of his or her appointment, or subsequently becomes such a member, he or she shall be a minister by virtue of holding the office of the Attorney General, and the provisions of paragraphs 2 and 3 of Article 183 shall apply to the office of the Attorney General. 3. If the Attorney General is not an elected member of the Assembly, but is qualified to be elected as such a member, he or she may be appointed by the President to be a minister. 4. If an Attorney General appointed to be a minister under the preceding paragraph resigns his or her office as Attorney General, he or she shall also vacate his or her office as a minister. 5. If the Attorney General is not a minister, he or she shall vacate his or her office if he or she ceases to be a citizen of Guyana, or if his or her appointment is revoked by the President. 6. If the office of Attorney General is vacant, or the holder of the office is for any reason unable to perform the functions thereof, the President may appoint a person, being a person qualified under the paragraph 1, to act in the office, but the provisions of paragraphs 2 and 3 shall not apply to a person so appointed. 7. An appointment under the preceding paragraph shall cease to have effect when it is revoked by the President. Parliamentary Secretaries. 186. 1. Parliamentary secretaries may be appointed from among persons who are elected members of the National Assembly, or are qualified to be elected as such members. 2. Paragraph 1 shall have effect in relation to any period between dissolution of Parliament and the day on which the next election of members of the Assembly is held, as if Parliament had not been dissolved. 3. A parliamentary secretary who was not an elected member of the Assembly at the time of his or her appointment shall, unless he or she becomes such a member, be a member of the Assembly by virtue of holding the office of parliamentary secretary, but shall not vote in the Assembly. 4. The provisions of Article 183 shall apply to the office of a parliamentary secretary, as they apply to the office of a minister. Functions of Director of Public Prosecutions. 187. 1. The Director of Public Prosecutions referred to in this article as the Director shall have power in any case in which he or she considers it desirable to do so. A. To institute and undertake criminal proceedings against any person before any court, other than a court-martial, in respect of any offense against the law of Guyana. B. To take over and continue any such criminal proceedings that may have been instituted by any other person or authority, and C. To discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by him or her or any other person or authority. 2. The powers of the Director under the preceding paragraph may be exercised by him or her in person, or through other persons acting under and in accordance with his or her general or special instructions. 3. The powers conferred upon the Director by subparagraphs B and C of paragraph 1 shall be vested in him or her to the exclusion of any other person or authority, provided that, where any other person or authority has instituted criminal proceedings, nothing in this paragraph shall prevent the withdrawal of those proceedings, by or at the instance of that person or authority, and with the leave of the court. 4. In the exercise of the powers conferred upon him or her by this article, the Director shall not be subject to the direction or control of any other person or authority. 5. For the purposes of this article, any appeal from any determination in any criminal proceedings before any court, or any case stated or question of law reserved for the purposes of any such proceedings, to any other court in Guyana shall be deemed to be part of those proceedings. Prerogative of mercy. 188. 1. The President may, a. grant to any person concerned in or convicted of any offense under the law of Guyana, a pardon, either free or subject to lawful conditions. b. Grant to any person a respite, either indefinite or for a specified period, of the execution of any punishment imposed on that person for such an offense. c. Substitute a less severe form of punishment for any punishment imposed on any person for such an offense, or d. Remit the whole or any part of any punishment imposed on any person for such an offense, or of any penalty or forfeiture otherwise due to the state on account of such an offense. 2. Subject to the provisions of the next following paragraph, the powers of the President under the preceding paragraph shall be exercised by him or her after consultation with such minister as may from time to time be designated by him or her. 3. In addition to the minister designated, generally under the preceding paragraph, a second minister may, in the manner prescribed in that paragraph, be specially designated in relation to persons convicted by courts-martial under the law of Guyana, and at any time when there is a second minister so designated, the powers of the President under paragraph 1 shall, in relation to such persons, be exercised after consultation with that other minister. Advisory Council on Prerogative of Mercy. 189. 1. There shall be an advisory council on the prerogative of mercy, which shall consist of the minister for the time being designated under paragraph 2 of the preceding article, who shall be chairman, a. b. The Attorney General, if he or she is not the chairman, and c. not less than 3 and not more than 5 other members who shall be appointed by the President, and of whom at least one shall be a person who is a qualified medical practitioner. 2. A person shall not be qualified to be appointed as a member of the Advisory Council under subparagraph c. of the preceding paragraph, if he or she is a member of the National Assembly, and not less than 3 of the members so appointed shall be persons who are not public officers. 3. A member of the Advisory Council appointed under the said subparagraph c shall hold office for 3 years, provided that his or her seat on the council shall become vacant, a. if he or she becomes a member of the Assembly, or if, not having been a public officer at the time of his or her appointment, he or she becomes such an officer, or b. if he or she is removed from office by the President, for inability to discharge the functions of his or her office, whether arising from infirmity of mind or body or any other cause whatsoever, or from misbehavior. Functions of the Advisory Council. 190. 1. Where under the law of Guyana any person has been sentenced to death by any court other than a court-martial for any offense against that law, the minister designated under Article 188, 2, shall cause a written report of the case from the trial judge, together with such other information, derived from the record of the case, or elsewhere, as the minister may require, to be taken into consideration at a meeting of the Advisory Council, and after obtaining the advice of the Council, the minister shall express his or her own deliberate opinion to the President, as to whether he or she should exercise any of his or her powers under that article in relation to that person. 2. The minister designated under Article 188(2) may consult the Advisory Council before expressing any opinion to the President under that provision in any case not falling within the preceding paragraph, but shall be not obliged to act in accordance with the advice of the Advisory Council. 3. The Advisory Council may regulate its own procedure. Subtitle 2 The Ombudsman, Appointments, etc. of Ombudsman. 191. 1. The Ombudsman shall be appointed by the President, acting after consultation with the Leader of the Opposition. 2. The Ombudsman shall not perform the functions of any public office, and shall not, without the approval of the President in each particular case, hold any other office of emolument, other than his or her office as Ombudsman, or engage in any occupation for reward outside the duties of his or her office. 3. Subject to the provisions of next following paragraph, a person holding the office of Ombudsman shall vacate that office at the expiration of 4 years from the date of his or her appointment. 4. The provisions of Article 225, which relate to removal from office, shall apply to the office of Ombudsman, and for the purposes of paragraphs 4 and 6 of that article, the prescribed authority shall be the Prime Minister. Matters subject to investigation by the Ombudsman. August 17, 1984, August 14, 2000, 192. 1. Subject to the provisions of this article, the Ombudsman may investigate any action taken by any department of government, or by any other authority to which this article applies, or by the President, ministers, officers, or members of such a department or authority, being action taken in exercise of the administrative functions of that department or authority. 2. The Ombudsman may investigate any such action as aforesaid in any of the following circumstances, that is to say, a. If a complaint in respect of the action is duly made to the Ombudsman by any person or body or persons, whether incorporated or not, alleging that the complainant has sustained injustice in consequence of a fault in administration. B. If the President, a minister or a member of the National Assembly requests the Ombudsman to investigate the action on the ground that a person or body of persons specified in the request has or may have sustained such injustice. C. In any other circumstances in which the Ombudsman considers that he or she ought to investigate the action on the ground that some person or body of persons has or may have sustained such injustice. 3. The Ombudsman shall not investigate under this subtitle a. Any action in respect of which the complainant has or had I. A remedy by way of proceedings in a court, or I. A right of appeal, reference or review to or before an independent and impartial tribunal other than a court, or